Welcome back. I'm Ladan Korhani. Today, I'm going to talk about what you should do if you want to change the final order. First of all, I will tell you that in order to change a final order, you need to show that there's been a material change in circumstance. You can't bring it back to court if, let's say, you changed your mind or you don't like the clauses anymore. It's important to show that. Otherwise, even if you bring it to court, it's going to get shut down pretty quick, and you're not gonna go very far with that. The forms that you're going to need for that is Form 15. We're going to start with Form 15. It's the motion to change form. Please make sure that you have your final order. If you do not have your final order, you can't complete this form, and you also can't file it. If you can't find your final order, you can go to the courthouse and you can request a copy, and they'll give it to you. So let's assume you have your final order, and let's assume that you can show a material change in circumstance. The form that we're going to start off with is Form 15. So you just complete the basic information, and page number 2, if you go into paragraph, so part B, paragraph 10, it's asking you what do you want to change? Is it decision making, parenting, child support? Whatever it is that you are looking to change, you check mark. And paragraph 11, what it's telling you is it's asking you what is the current term, meaning what's the term in the final order that you want to change. So you actually have to write it out. So let's assume that you want to change parenting. And let's assume that the final order says that you have alternating weekends from Friday to Monday. So you literally put that on. You put the respondent has parenting time from Friday to Monday, alternating, and you put that in there, and then it says requested change. That means what do you want to change that term to? Let's assume you want primary care. The respondent shall have primary care of the children, and that's what you would put. So you do that for whatever paragraphs in the final order you're looking to change. Next page, you sign it. You sign the part about the changes that you want to make. Okay. And now this part, the page 4, which is part C and D, this is sworn. So whatever information you're putting in there, just know that you're swearing to this information. So there is not really a lot of space here. Again, these forms, they don't give you that space. If you're not filling this out online, I would just suggest printing a page and just putting, Schedule A. So for instance, paragraph 13. Briefly give the facts that show why the court should change the order. So this, you need a lot of space. So you just see Schedule A and put in a piece of paper Schedule A, and then give your reasons. Okay, and you're going to do that for the whole page. And the next page is the signature, but it's again, it needs to be sworn, meaning it needs to be signed in front of a commissioner of oath. You can go to the court, and the court clerk can do that for you, or you can hire a lawyer or a paralegal to do that. You have to make sure that the final order is attached. You also have to, if there are if there's a change in support that you're doing, you need to make sure that you have a Form 13. I went through the Form 13 in my other 2 previous segments, but just to go briefly review the Form 13, you need your income, your expenses, and you need your last 3 notices of assessment. You fill that out. It also needs to be commissioned, meaning you have to sign it in front of a court clerk or lawyer or paralegal. You fill that out if there are support changes. If there are changes to do with decision making or parenting time, so if it involves children, you need to fill out a Form 35.1. That's an affidavit for custody and access. It's also a sworn document. You just fill out everything that it's asking you. It's asking just specific questions. And once you've completed that, you can attend court and have the court clerk sign everything, but before you do that, I would recommend that you make 2 copies. So you have the original and you have 2 copies all filled out. You go to the court clerk, you ask her to sign everything or commission everything rather, and they're going to take the original from you. That means that your motion to change has been issued and they're going to give you your first court hearing. Usually it'll be about 6 weeks or 7 weeks away. And the 2 copies that you have, one needs to be served on the other party and the other one is for you. So just make sure that you're not the one serving anybody but you. It's got to be served personally. You can't email it. You can't mail it. So once that's done, and whoever does that needs to attend court to fill out what's called a Form 6B. It's an affidavit of service. That affidavit of service also needs to be commissioned. It's a sworn document stating that the other party was served, the method, time, and date. And so this way the court knows that you have served the other party. And now it's a little bit different with the motion to change in some jurisdictions, not all. So some jurisdictions, some courthouses, they say that after first appearance, you need to go to a DRO before going to a case conference. A DRO is similar in that you file documents similar to a case conference brief. You use a case conference brief, you just rename it DRO. It's the same form, but the difference is that you are in front of a senior lawyer, a dispute resolution officer, and not a judge. So the importance of that is if the DRO officer does not see a material change in circumstance, it is unlikely for you to proceed to a case conference or settlement. But again, not all jurisdictions have that. You would be finding that out at a first appearance. They would let you know whether it's a DRO or whether it's a case conference. Thank you. Until next time.